The U.S. Supreme Court allowed the Trump administration to move forward with new rules requiring all U.S. passports to display a citizen's biological sex rather than their gender identity. Now, you may recall back in 2021, the Biden administration allowed Americans to select X when it comes to their sex marker for their passport instead of male or female. Just put X. So what does the Supreme Court's ruling tell us about where they might be when it comes to the radical left's transgender crusade? Well, here now to discuss this and more is Ohio Attorney General Dave Yost. He joined 25 other state AGs in supporting the Trump administration's passport case. Attorney General Yost, welcome back to Washington Watch. Always great to have you, my friend.
It's good to see you, my friend.
Okay, so let's start by going back. Your initial reactions years ago when the Biden administration first announced the passport policy. What were your thoughts?
Well, obviously I was surprised and not happy. It's kind of what we lawyers call a legal fiction. And government documents ought to reflect reality. Look, I don't care how you want to live your life as an adult. This is a free country. But your government documents that say who you are should reference who you are.
Yeah, so that was exactly where I was leading with it. Did they have any legal backing or any reasoning, the Biden administration, for using X as a gender policy?
Well, I don't think they had any good reason. I mean, they couched it in terms of equal protection and First Amendment free expression. But as the Supreme Court described in its very brief order yesterday, that is not really a valid argument.
So now we come up to where we are right now. You joined some other 25 state attorneys generals in an amicus brief, as well as some leaders of the Arizona state legislature, supporting the Trump administration's passport case here. Why is this to you such an important issue and something that we need to stand up on right now?
Well, there's a number of reasons. Obviously, the baseline reality is there are two sexes. That's been across cultures and across history that we've understand. There's male and female. So if you're part of the reality-based community, I think you want your government to be talking about those facts. It says nothing about someone's individual sense of their own identity, but it does go to whether those government identity documents match your presence. Maybe equally important from a legal point of view, these passports are the United States government's representation to foreign entities that this citizen is who they say they are. John Smith, who's 6'1" and 200 pounds and a male. The notion that a judge is allowed to tell the president in the exercise of his Article II foreign relations powers what he can and can't do with relation to those documents, absent some kind of fraud, waste, or abuse, is really problematic. We have judges that are way outside their lane in this country. I don't mind saying that. It's not the entire judiciary. We've got some great judges who disagree with the president and still follow their oaths. But we also have some activist judges that are making it up as they go along. And I am glad that the Supreme Court restrained this abuse of judicial power.
Yeah, absolutely. So how far reaching do you think this is going to be? I mean, the Supreme Court, for example, is going to be deciding on a case later this year regarding a Colorado Christian therapist who is prevented by state law from helping young people in that state who are distressed about their gender identity. I mean, some of these people want to achieve their chosen goal, I guess you could say, to grow comfortable with their bodies while at the same time avoiding harmful drugs and procedures. So based on what the court has said in this passport case, do you see this as any indication that may point towards how they might rule on other cases related to the whole transgender crusade?
I think it's of limited value for that. Anybody that wants to predict what the court's going to do is betting against the House in a way. Look, this was an emergency docket decision, not a decision on the merits. It's putting on hold the local activist trial court judge's ruling until such time as it comes up to the Supreme Court on the merits. Secondly, the Colorado case that you mentioned, which is a fascinating case, and I appreciate our friends over at ADF who are representing that counselor, is a different kind of case. That sounds in the First Amendment. It doesn't invoke the foreign affairs. So while I'm hopeful for that case, we'll have to watch the oral arguments and wait for the decision.
Okay. Last question real quickly, and we've only got about a minute left, but a little bit closer to your neck of the woods. The Sixth Circuit Court of Appeals ruled against an Ohio school district on the pronoun mandate. Your thoughts on that?
Well, it was a great decision by Judge Murphy of the Sixth Circuit. Olentangy schools had a rule that said students have to go by their colleagues' choice of pronouns, and that you could be disciplined for harassment if you didn't. And the court said, no, that doesn't qualify as harassment. School, you're allowed to actually police harassment, but you're not allowed to do it by controlling speech. First Amendment still applies. Free speech still applies. This is still a free country.
Great decision indeed. Thank you so much, Ohio Attorney General Dave Yost. Always great to have you on the program. We appreciate it. Have a wonderful weekend.
You too, sir.